Help me with that.
Yeah, I think what that's missing, we trace this out in our opening brief, is that contracts are extraordinarily flexible, and you can, and people do.
Yes. Okay. Your brief does go into that, that Congress could have easily written a statute that does this and says that those individual officers have to agree with the federal government to be bound under federal law. I agree. It could have done that. And you say it could have done this in 15 different ways in your brief. I agree with you. My concern is it didn't do that. It could do that, but it didn't do that. It left it to the states.
I think that's really where I fundamentally disagree.
Okay.
I think Congress did do it. What it said in this statute is that, first of all, obviously the states need to accommodate religious liberty, and then it is clear as day that if you agree to be an officer or other person acting under color of state law in this statute, and you deprive a person of their religious liberties in violation of this statute, then you are subject to suit where you will be the defendant in a cause of action for appropriate relief. That is on the face of the statute. And the individual officers, they can agree to take the job or not. They can demand higher wages. They can demand indemnity like Louisiana gives it. And I think one of the things that really breaks down in their argument is they admit that it applies to them. They admit that they need to comply within the scope of their work. And it comes not just with the substantive condition, but also with a remedial one. And then I also do want to just come back to, in this court's precedents, it's made clear that that Congress can combine the spending power with the necessary and proper clause to impose liability. I mean, criminal liability in Salinas and Saubery.
I don't doubt it could, and I don't doubt that when it's protecting its money, as in some of those cases, Salinas, that interest is clear. What